applicant avers that the Supreme Court presidential election petition rules, in particular Rule 22, are a basis for such an application. Secondly, he avers that he is a registered voter, and therefore the matter which names certain particular individuals as respondents, quote, directly affects him as an individual and as a matter of public interest, end of quote. Thirdly, the applicant avows that he, quote, understands the presidential election procedure on monitoring and evaluation and the whole system and how it was supposed to work, end of quote, especially as he himself, quote, was to vie as an independent presidential candidate, end of quote. Fourthly, the applicant states that he is, quote, the chairman of the independent candidates lobby group that was involved in training agents overseeing the general elections, end of quote. Such essentially are the grounds whereupon the rest of the applicant's case that this court should formally commit itself to entertaining his case as a respondent alongside that of the various individuals whom the Institute for Democratic Governance had chosen to list down as respondents without any formal signal of consent from them. As already recorded, the Supreme Court's time and other resources are at this moment gravely strained, yet must be deployed in essential courses of service to the Kenyan people. There is necessarily an obligation of judicial conscientiousness, which at this time dictates that the court must decline to take on those courses that run contrary to the public interest and that make none but nominal endowment to the true cause of dispute settlement. The instant application falls squarely in the said category of tendencies negating the court's service commitment. Accordingly, the instant application is hereby dismissed, and its costs shall devolve to the applicant, and the court makes orders accordingly. He will meet costs. Yeah, he will bear the cost.
The other one will be read by Justice Wanjala.
There are two applications. The first one is by Mr. Caleb Wamaya, who has applied to be admitted as an interested party. We have considered the arguments made which are attached to his application, and we are of the view that the applicant has not demonstrated that he has an identifiable stake in the present petition. Neither has he demonstrated that he will be prejudiced if he is not enjoined as a party. Taking into consideration the issues he raises have already been addressed by the parties. Having considered the application along those lines, by a unanimous decision of the court, we find that the applicant does not qualify to be joined as an interested party, and we decline to admit him as such. There will be no order as to costs. The next is the application by the petitioners in presidential election petition number 4 of 2017, wherein the applicants seek orders for scrutiny. The application contains 20 prayers in all. We have considered this application. We have also considered the affidavits in support and opposition to the application. We have paid due regard to the oral submissions by counsel for the petitioners and the respondents. And in arriving at the orders we are about to make, we have been guided by the principles laid down by this court in the Peter Gatirao Munya case regarding applications and orders for scrutiny. We are further guided by our ruling of 28th October 2017 in Raila Odinga and Kalonzo Musyoka versus IBC and others, wherein following an application for scrutiny by petitioners in that petition, this court further clarified the grounds upon which an order for scrutiny may be granted or partially granted or declined altogether. Pursuant to the foregoing, by unanimous decision of this court, we make the following orders. The second respondent is hereby ordered to grant access to all original Forms 34A, Forms 34B, and Form 34C to the petitioners herein, in accordance with prayer number 14 in that application. The second respondent is also to avail a certified copy of the voter register to the petitioners at the cost of the latter. That means the petitioners, and this is in accord with prayer number 17. The remaining prayers are hereby declined. The said prayers have been declined on the basis of very cogent grounds, which will be elaborated in a detailed version of this ruling to be issued by the court at a later date. Some of the prayers have been declined due to the sheer impracticability of their implementation, given the short time left for the determination of the petitions at hand. Others have been declined because they were not pleaded with sufficient particularity in the petition, yet others were declined on grounds that they are couched in such general terms as to be no more than fishing expeditions. Orders accordingly.
Thank you, Justice Wanjala. Give him the microphone.
Your Lordships, I want to say this. I have a feeling that you've been too cruel to my application. Because for one reason, this is an application that was filed on 7th. It was lodged on the same day of 7th of 11th, 2017. As I had said yesterday, it was an ex parte. No party was opposed to it. But then, I've not been allowed to canvass my application. And therefore, my rights have not been enforced. Your Lordships, I have a feeling that I've been discriminated. Could it be just because I was representing myself? And for that reason, I feel Article 1 that talks of the preamble, Article 10, the national values and principles of governance, Article 22, that talks of Article 22, sub-Article 1, that talks of the enforcement of the Bill of Rights, 27, that talks of discrimination, and 47, that talks of fair administrative action, and 50, that talks of a fair hearing. All the Constitution has been abused and infringed on. It's unfortunate my application has not been allowed to be enjoined, but for that matter, I'm going home a disappointed person, I'm going home when I knew this was the last resort court, having been denied my rights by the IBC. Now the same rights are being denied by the highest court in the land. Your Lordships, it's unfair, it's too cruel, it's not right. I rest my case.
Thank you, gentlemen. You were here last night, isn't it? Stand up, please. You were here last night. And I told you we have more than 19 million Kenyans, registered voters. If we allow each one of them, or any of those who want to come here, we will require a year or two to determine this kind of petition. What you do, find a way, talk to your MPs, let them give us a year or so to hear a petition like this, and we will accommodate all of you so that we hear your views. But for you to come and tell us that because we have refused to allow you to come into this petition, we are abusing your rights, I want you to also think about that and check your language. You understand? Yes, as I've told you, we have more than 19 million Kenyans. If we allow everybody, we will not move. Our position is, as we have said, we have done what we think is right, and we have dismissed your application. Thank you. Now, can we start? Let's.
Yes, my Lord.
Yes.
Good morning. In regard to the directions you have given to our application for scrutiny, we are requesting if the court can clarify a couple of things. One, that the production and scrutiny be overseen by the registrar of the court, that we be granted leave to file a report of the findings of that scrutiny, and that specific timelines be provided for the production of the or access to the material that has been granted, so that we don't lose time.
My Lord, perhaps before an order is made, my understanding of the prayer by my learned friend is to be given access. Yesterday, my Lord, before, or rather in the course of the argument, you did ask where the documents are, and we confirmed to the court that the documents are within our warehouses in Nairobi. And what I thought my learned friend asked for is access, and we are perfectly willing to give that access. I don't see why the court now should be in.
Gatonye, please arrange for somebody to open where they are. Mr. Ndubi, send your representatives there, and you have access to those documents. Then you can make a report of what you have seen, and I think Mr. Gatonye, I think if he wants to take a copy or two of some of those forms, please allow them to do that, so that they can, if there is anything they want to point out of that. So give them access, and if you can, avail a photocopying machine in the what?
So long, my Lord, as they undertake to pay any photocopy, any certification. Yeah.
Photocopying, you can,
it's public duty.
We have already told them that they will get a certified copy of the register
at their own cost.
At their own cost, because in your replying affidavit you said it is going to cost millions to photocopy that. So, Mr. Ndubi, is up to you what part of the register you want to photocopy. You can do that.
Very well. How about timelines? Because it's essential. Okay, perhaps we assume that the order is running, so we will send our people now.
Mr. Gatonye, please ask your people to avail enough staff so that this can be done and we get the report by tomorrow evening.
Most obliged.
Yes.
Thank you.
My two learned friends appear to leave us out. We are actually very, very important in that exercise. Okay. My Lord, as I understand it, so that we do not leave here and then generate other reports, is access being given. In that access, I do not see another report being done, because a report will be now evidence. We would want, number one, to be present when that is going on. As a matter of fact, if Mr. Gatonye could facilitate a recording of what is being done, not that we impute improper motives, but we are here to make sure everything is done correctly, so that we are not given one document which mutates into something else. We would want to be present throughout that exercise, and Mr. Gatonye should have big enough a warehouse to enable all the parties to be present.
But
yes.
Again, sorry, my Lord, we cannot allow a very large number of people. So perhaps my learned friend Mr. Ndubi can give some indication about the number of persons he wishes to send to go and have a look at the document.
Two things I would say. It would be meaningless to undertake that exercise as a result of this direction from the court without the liberty to do a report to the court, whatever that report is. Two, if I recall, the order in terms of how we quoted it, all parties should be at liberty to participate. Thirdly, the number, because I recall from, though I did not participate in petition number 1 of this year, there was difficulty in terms of logistics because the earlier orders given by the court was 2 people to access, to participate, and it was becoming difficult. So we'll be requesting to have at least 10 our representatives to engage.
10 people?
10 people, yes. Because you see, my Lord, it's easier if you have 10 people and they share the work, so that they reduce the time taken rather than having 2 people to do repetitive work for a long time, so that even the report becomes meaningless to the court once it is ready, if at all in time.
The difficulty we have with large numbers is exactly what happened barely a month or so ago, where our opponent crowded the venue and then reports started being generated. It's access to certain forms. We can have 2 people looking at Form 34A, 2 looking at 34B, and 2 looking at 34C. So each team can have 6 people. But having 10 and then another 10 and another, it's too big a group.
I think that, Mr. Ndubi, that sounds reasonable.
My Lord, what I think is that first, you will recall that the third respondent opposed our application. They were not interested in this exercise that we were asking for. They now seem to be particularly interested in it. I understand, of course, they would, but it is, like Paul Mwangi said yesterday, breathing hot and cold. 10 people
who is likely to be affected with an adverse word?
My Lord, whereas we appreciate that the third respondent has a direct stake in the outcome of the petition, we also know that all Kenyan voters and indeed citizens have a direct stake too, so that this matter cannot be taken as if it is a dispute between individuals. It's a public issue that is being discussed. So 10 is not unreasonable. In fact, if he proposes 6, 4 more is not excessive. It's not unreasonable, neither is it disproportionate.
If I may add something. For the second respondent, I was personally involved in the last exercise. And we were not careful about the numbers. Everything was going on very well until there was an invasion of numbers.
Invasion, yes.
And everything became chaotic. So if we can limit the numbers, also we must consider the space. We don't have Milimani Hall. And I think it can be worked out. But if we go this way, we're going to have a problem again.
We're not talking about invasion. We are giving a specific
We
number.
had an invasion last time.
We were not there.
Okay.
Well, my lord, we are giving a specific number. We have not talked about people coming in willy-nilly. We are talking about 10 people. We are not asking for hundreds of people.
Fine. Gentlemen, the petitioners to have 7 people, the third respondents to have 7 people. IBC to avail the number of staff they think will be required to facilitate the exercise.
Most obliged.
And then if you are noticing any issues, it would help if both of you can agree and say this from 34A appears altered or something like that, and you record that so that it is like by consent.
Yes, and if we have difficulty, we'll be at liberty to approach the court. Thank you.
Very well.
Thank you.
Thank you. Yes, Mr. Musyoki.
Yes, my lord. I appear for the first petitioner.
Yes.
With Mr. Mark Ouma and Mr. Mark Ngatia.
Yes.
We are ready to proceed with the petition.
Yes. Sorry, just before you start, Mr. Dubi and Mr. Ngatia. Yes. It would help if you can have that report tomorrow by 3 o'clock.
Yes, indeed. We were just organizing to send one of my colleagues here to organize our team.
I do not anticipate any report at all. It's an access being given. If he wants to record anything, that's his personal report, not a joint report.
No, my lord, I think what we can do, either we have a joint report if we agree, if we disagree, we do our respective reports. Because it doesn't mean anything if we are going to conduct an exercise and the court has no benefit of its outcome. It might as well have been rejected then.
My lord, I thought the order requested by Malan and Friend was one for access. That order has been granted. There is no order for furnishing the court with either a joint or individual report. It is upon him, after examining the document, if he believes that he should file anything in court, for him to file. He shouldn't involve other people.
Precisely.
The point of access, the meaning for access is that we have asked for that scrutiny and access on account that we have to compare what we have with what has been produced in court and what they might be having. So it is important that the court has the benefit of the outcome of its orders. It is actually completely meaningless if we are going to do nothing.
Mr. Ndubi?
Yes, my lord.
Please make a note of what you have seen. Make a note of what you have seen, make a report of what you have seen. Mr. Ngatia, it would be, in my view, good if you also, especially if they are pointing out something, it is also good for you to say whether it is correct or not.
But in the last sentence, I saw yet another danger. Now, instead of access, it is a comparison of what he has and what IEBC has. My lord, we are now expanding this into a very dangerous monster. My learned friend is not going to come to that hall with other documents to compare, because we now start to see a way that documents could be exchanged. We are going without a single document. What I say of him is what I say about my team. We go without any documents. We go to access with our eyes, with our cameras, and with our everything. If he wants then to make an application, he's entitled to do that.
No, my lord.
But to allow him, my lord, to go with thousands of documents, and then he starts to compare, that would be very dangerous.
I think we are really taking time away from hearing the petition. Yes. The order is clear. You have access. What you do with your access is your business. So just go get access, get whatever information you want out of there. Once you are out of the warehouse or whatever the place is called, do with it what you want. The order that has been granted to you is for access.
My lady, what we did yesterday in our application to justify the orders that you have granted was to demonstrate certain discrepancies. I do appreciate, my lady, when you say we can do what we have access, but it is also inappropriate and improper for Mr. Gatonye's client to limit us to say you can't come with any piece of paper with which we can compare what they have, because we have demonstrated before this court that there are discrepancies between the forms that we are able to access through our agents and those that they produced on the public portal.
Counsel?
So, yes, my lady. My lady, sorry.
Is there any part of the order you did not understand?
No, I quite understand it.
Thank you. Now, if you want it, the typed one, you could get that. If you just comply with the order, then you come back and we deal with that after you've come back. I agree with you. It's pointless to just go and look and walk out. But you will define what you want to do after you've come out. And then you bring it to us.
Yeah, indeed, like I said, we can conclude by saying if we experience any particular difficulty that we think is important for the court to deal with, we'll present that difficulty.
Let's proceed that way.
Thank you.
Thank you.
Yes, Mr. Musyoki. Please start. You have introduced your colleagues. You have 1 hour. How you divide your time is up to you. But we will be very, very strict with the 1 hour.
Thank you, my lord.
Yes.
My lords and my ladies, the petition before you is challenging presidential elections which were held on 26th of October 2017. And the basis of that petition, my lord, is that it is our view and our submissions that it was held under situations which were in violation of the Constitution on the applicable electoral laws. My lords and my ladies, you ordered the first and second respondents to organize and conduct fresh elections with strict conformity to the Constitution of Kenya and the applicable election laws. That was the order of this court. My lords, it's our submission that procedure of conducting presidential elections is expressly provided for in Article 138 of the Constitution, which makes it mandatory for nominations to precede any presidential elections. Actually, it's so important. The issue of nomination is so important that that article, that is Article 138, gives a situation where we can have a president without the ballot, such that if only one candidate is nominated, duly nominated, that candidate shall be declared the president-elect. My lord, this court has heard before, and it is the position in law, that elections is a process. It's not a one-day event. It is a process, and in our submissions, it must be triggered by or initiated by way of nominations. My Lord, it has been admitted by the respondents that no nominations were conducted for the fresh elections held on 26th of October. My Lord, and my ladies, in our record, we have annexed JHM1, which appears at page 1, and that is immediately after the affidavit. My lords and my ladies, that annexure is Gazette Notice number 8751 of 5th of September 2017. It is purported to be, the notice is purported to be gazetted pursuant to laws which have been cited there. That is a proof that the first and second respondents were aware of the provisions which they were supposed to comply with. Of interest, my Lord, is Article 137, cited there, Section 2 of the Elections Act, Section 14, and other sections of the Elections Act. My Lord, the question we want to ask ourselves at this juncture, did the first and second respondents comply with the conditions and the laws it is cited in this Gazette notice? And our answer to that is a no. My Lord, I will refer you to Section 14C of the Elections Act. That section, my Lord, is a section of the law which initiates presidential elections. Its marginal note is initiation of presidential elections. And my Lord, what it is provide is that the notice, which I believe is the one I've referred you to, the Commission shall publish a notice of the holding of the election in a Kenya Gazette and in electronic and print media of national circulation. And subsection 2 of that section says, the notice shall be in prescribed form and shall specify the nomination day for the presidential election, and 2, the day the poll is to be taken. Look at this notice, my lords and my ladies. It does not specify the date for nominations. Actually, item B of that notice says there shall be no nominations for candidates participating in the fresh presidential elections. That's a serious deviation from constitutional provision and the Elections Act. Now, Section 137, not Section 137, sorry, Article 137 of the Constitution give qualifications for persons who are to be qualified to be nominated as presidential candidates. Well, we have a definition of what presidential election is. under Section 2 of the Elections Act. And it says, my Lord, presidential elections means an election of a president in accordance with Articles 136, 139, 1B, 146, 2B of the Constitution. My Lord, at that instance, I want to refer you to Article 146 of the Constitution. That 146(1)(c) says the office of the president shall become vacant if the holder of the office, C says, otherwise ceases to hold office under Article 144 or 145 or under any other provision of this Constitution. So Article 140 falls within under any other provision of this Constitution. So, my lords and my ladies, the moment this court annulled elections of 8th of August 2017 on 1st of September 2017, the office of the president fell vacant. And in its directions and orders of that day, this court was alive to the fact that the elections, the fresh elections, were to be conducted under the provisions of the laws which are applicable, not at the whims and the desires of the first and second respondents. My lords, these are articles of the Constitution written in simple English and do not need special interpretation. My lord, there are 5 instances under the Constitution where fresh presidential elections can be triggered. We have Section 139, Article 139, sorry, Article 140, that is the article which results into what we are doing in this court. Article 145, 144, and 146. Those articles I've mentioned, my lords and my ladies, give timeline of 60 days. All of them, the ones I've enumerated, they give timelines of 60 days. So if a narrative is brought up on the constraints of this Section 60, this section on the timelines of 60 days, we must pose a hypothetical question. We are aware that the excuse or reason given for how these elections were conducted is time constraints. My lord, if, God forbid, the office of the president becomes vacant under Article 146, or other articles, for example, due to incapacitation or death, does the first and second respondent tell us that because the timeline is given in those articles, we don't have time for nomination. They will pick for us or for this country candidates who actually participated in another elections. No, my lord. And it is our submissions that 60 days is enough for nominations. And other processes. Section 14, subsection 2 of the Elections Act. My lord, only requires, that is the subsection 2, paragraph B. It requires the first and second respondent to specify the day or days on which the poll shall be taken for the presidential election, which shall not be less than 21 days after the day specified for nomination. Simple arithmetic, my lord, says that from the date of nomination to the date of the poll, the minimum required days is 21 days. And what we are saying, my lord, is that after you issued your orders on 1st of September 2017, the first and second respondent would have done a very simple thing. Put up a gazette notice on the same day, specify the day for nominations, and make sure that the date of nomination is at least 21 days before the date of the poll. In essence, my lord, the first and second respondents, in our view, went into a fishing expedition of other provisions and other authorities outside the Constitution and election laws. The only fresh elections, my lord, which can proceed under the Constitution without nominations is under Article 138(5). That article actually goes on to identify and in quotes nominate the candidates who shall be in the fresh elections, and even lowers the period to 30 days. And it also lowers the threshold of the winning candidate. We cannot call on a rocket. It's not a rocket science, my lord, to interpret what fresh means. That issue was brought up before Honorable Justice Matiho in petition number 471, filed by the first interested party, I believe, second interested party. And he made it very clear that fresh meant anew. There's no special definition. So our position is you cannot start and have a presidential election, or any other election for that matter, without nomination. It's an issue of comparison, my lord. And the first and second respondent can confirm, because it is public knowledge. When an election of a governor, a senator, an MP, MCA, and the rest is nullified, Do they retain the candidates who were in the previous elections? They go for fresh nominations. So why are we lowering the bar when we come to a serious seat and position, like a presidential seat? Actually, the symbol of national unity. My lords, when elections are null under Article 140, none of the previous candidates, none of the previous processes is saved. All processes are done away with, and actually in your order you said that election was null and void. So it's like it did not exist. We all know the meaning of that word. Even looking at the certificate of nomination.
Sorry for interruption, Council.
Sorry, my lord.
When you are making a proposition and you have an authority for that proposition, please cite that authority at that point so that we don't have to be rewrite again. Like the position you have said that none of the what of the processes survives. If you have an authority, please cite it at that point.
My lord,
so that as you move, if you have any authorities, as you move, when you are making a proposition, cite it there.
My lord, I'll refer you to page 69 of the record. Sorry, my lord, page 26 of the the supporting affidavit. The numbering of the record is different. The petition and the affidavit is numbered A1 to A19, 119. So I would refer you to page 26 of the supporting of the annexes. My lord, we have proceedings. Actually, it starts from page 9. Proceedings and judgment in petition number 514 of 2017. My lord, at page 17, there was a reference to this court's advisory opinion number 2 of 2012. Again, in our list of authorities, which we found on 13th of October, there is authority of that is at page 233. Harford versus Lindsay. It's a Queen's Bench decision at page 858. My lord, in that authority, it says the nomination, and we violated that part, is an essential part of elections. Without nominations, no elections ensues. And while on that point, my lord, on the proceedings I've referred you to, actually, it is the third respondent in these proceedings who, my lord, and I believe they have not changed their position, stated, my lord, and I quote at page 17, because we are relying on advisory opinion number 2 of 2012. They say at line 8, all critical steps of the electoral process, page 16, line 10. Malan Senior, Mr. Ngatia, said nomination is a critical stage in the conduct of election. It's so critical that in Article 1.81, the one I've just referred you to, of the Constitution, candidates. If one candidate is nominated, the candidate is declared unopposed. And that, I believe, still remains the position in advisory opinion number 2 of 2012. Yes, it was a submission, but the judge agreed with you. And that's why I said I believe they have not changed their position. Your Lordship, my ladies, after the Gazette notice of 5th of September 2017, they are followed 2 others by the first and second respondent. In those 2 Gazette notices, one appears at page. There is one at page 5 of the affidavit, dated 13th of October 2017, and the other one at page 3 of 29th September 2017. What they did in those 2 Gazette notices, my Lord, I believe you will look at it for purposes of saving time. They added a candidate on the 13th, 5 candidates actually, on the 13th of October 2017. And in those Gazette notices, they specified that candidate, one of the candidates who was the previous election, that is Cyrus Jirongo, was not qualified to be nominated. Then the question would be, between 5th of September and 13th of October, what processes were being carried out to ascertain who qualifies and who doesn't? In Gazette notice of 5th of September, the campaign period was supposed to end on 15th of October. In Gazette notice of 29th, it was extended to 24th. Giving the 2 candidates who were appearing at that time in the Gazette notice 48 days. Come 13th, the 500 candidates had 11 days of campaign. Then on 24th, before I go to the 24th, my Lord, this one of the 13th stated that Cyrus Jirongo was not qualified. He was not qualified to run and will not appear in a ballot paper. It's in the public domain that the first batch of ballot papers arrived in this country on 21st of October. As at that time, the public and the electorate had been told Cyrus Jirongo was not in the ballot. Then on 24th, my lords and my ladies, a gazette notice is issued putting back Cyrus Jirongo in the ballot. As at that time, campaign period had expired. What is addressing this the later notice, my lord, is that the ballot were already in this country, and the name of Cyrus Jirongo was in the ballot. This, in our view, did not only disadvantage that particular candidate, but also those who would have intended to vote for him. My lord, these breaches of the law and the constitutional provisions had impact on the results of these elections. My lord, any elections conducted outside the realm of the Constitution and the applicable electoral laws, whether or not it involved one or two or three candidates, should not be allowed to stand. It is important that we guard the spirit of this Constitution and the electoral laws we have at present. We will be asking this court to find that those breaches went into the core of the elections. We must have a situation, my lord, where we have predictable processes such that a century down the line, our generations will look back and see we have firm laws. It doesn't matter, my lord, who is dealing with a certain institution. My lord, I have 29 minutes. I want my learned friend, Mr. Ouma, to take the remaining part of our submissions.
If it may please your lordships, your ladyships, my name is Ouma. I appear for the petitioner together with Mr. Musyoki. Your lordship and your ladyships, the case before you is a very simple, very straightforward case. It is a case about ballot access. It is a case about the conduct of elections. I wish to start these proceedings by underscoring the importance of nominations to the electoral process. Your lordship and your ladyships, as a matter of fact, nomination is at the epicenter of an election. And that is why, to avoid any controversy as to the issue of nomination, Article 138, in very clear and express terms, set out 3 circumstances under which nominations occur. Your lordship, on the date set for nomination, if no candidate is nominated, Article 138 is imperative that the election must be cancelled, and a new presidential election held within 60 days. And we will see the importance of that in a few minutes. Under Article 138(1), if only one candidate is nominated, that candidate is entitled to be declared elected as president. Your Lordship and your Ladyships, if 2 or more persons are nominated, then you have a contest between 2 people. And it is only then that Article 138(2) says you go to meet the people at the ballot. I can read for emphasis Article 138(2). If 2 or more candidates for presidents are nominated, an election shall be held in each constituency. I would want to stop at that point and we look at the language that is used under Article 138(1) and Article 138(2). It is not in doubt that the election held on the 26th of October was a presidential election. In that election, if only one candidate for president is nominated, not was nominated, but is nominated, then the candidate shall be declared elected. The word used is in the current present tense, and it ensures compliance. Your Lordship, tied to 2 or more candidates proceeding to the ballot is Article 138(3), that says that the polls shall be taken by secret ballot on the day specified in Article 101 in the places and in the manner prescribed by an Act of Parliament. Your Lordship, the regulations that are made under the authority of the Elections Act provide in express terms that every ballot paper shall contain the name of validly nominated candidates. In this case, Your Lordship, it is not in dispute that no candidate was nominated for this election. There was no contest because no 2 or more persons were nominated, because an election only proceeds to the polls when 2 or more persons are nominated. So there was no contest, and under Article 138(8)(a), that election ought to have been cancelled 21 days to the election in compliance with Section 14. Your Lordship, I wish to take you to Article 138(7). Before you go to Article 138(8), you have to pass through Article 138(7). 137, I mean. In that article, a person qualifies for nomination. It is requirements for a person to qualify for nomination before you go to the procedure at the presidential election where you are nominated. For the avoidance of doubt, Section 2 of the Elections Act defines nomination as delivery of papers to the IEBC in compliance with the Constitution and the Act. Therefore, a look at Article 137, there is a personal duty on every prospective candidate to ensure that he is qualified for nomination. Before he goes to nomination, it is his personal duty to ensure that he is qualified for nomination. And under Article 88(4)(k), it is the constitutional mandate of the IEBC to ensure and monitor compliance with laws on nomination. It is a constitutional duty, it is an imperative duty, and this court has stated in the case of Speaker of National Assembly, which is on page 51 of our list of authorities, that constitutional procedures are imperative. They cannot be waived, they cannot be ignored, and they cannot be disregarded. Your Ladyships and your Lordships, it is not in doubt that the third respondent is aware of all these articles. And that is why, if you look at page 208 of our list of annexures. At paragraph 11, at paragraph 9, Senior Counsel Mr. Ngatia accepted that nomination is an essential part of the election itself, which affects the outcome of the election. That was an admission given in open court, publicly, and voluntarily. It was not coerced, and it was an admission in court. Your Lordship, we would have expected, as a candidate in the election, that having known that an essential constitutional requirement was being violated, he ought to have taken a personal duty to defend the Constitution under Article 3.2 to ensure that non-elections proceeded on that day. On the very basis, Your Lordship, that while knowing that nominations and qualifications for nominations were imperative, and while admitting openly in court that they were imperative, he goes ahead and then participate in the said elections. He would be required to take an oath under the third schedule, which oath would require him to swear an affirmation that he will obey, he will protect, he will defend, and he will preserve the Constitution and the law as established. Your Lordship, I wish to take you to some facts that are not in dispute. The first fact that is not in dispute is that no candidate was nominated for the election of the 26th of October 2017. Under Article 138.2, we've seen that if there are no candidate who is nominated, an election cannot be held. What was held on the 26th of October 2017 was not an election within the confines of the Constitution. We have looked at the annexures of the third respondent, and they have annexed the certificate of nomination for the 8th of August, 2017. The nomination for the 8th of August is not in doubt, expired upon the close of polls on the same day.
Can you please give me an authority for that?
An authority for?
For the fact that that nomination expired, because that is the issue that you are bringing out.
Yes, that is the issue you are bringing out, Your Lordship. I don't have an authority at hand, but the authorities we have say that before you can move to the electoral contest at the voting, people must be nominated. And it is an express requirement of Article 138.
That's all fine.
Yes.
Article 138 starts with the general election.
Your Lordship, it is a presidential election.
Yeah,
it is not a general election.
Okay.
Yes. It is a presidential election. The words are very clear.
Yes.
At a presidential election, someone qualifies to be nominated as a candidate after having met the qualifications under Article 137.
Mr. Uma,
yes.
The issue here is this.
Yes.
The candidates who participated on the election 26
yes.
were nominated for election of 8th.
Yes.
You are saying, as far as you are concerned, that
yes.
nomination expired.
Yes.
So what I want is an authority for the fact that that nomination expired and that they needed to go under a further or a fresh nomination.
Or a fresh
nomination. And then we move on.
Your Lordship, then first I would direct you to Regulation 16. That is the process where people apply for nomination. And it says specifically, you apply for nomination at that election, not any other election, at that election. Regulation 16. But Your Lordship, let me just stretch your question a little bit. The third respondent was nominated for the elections of 2013. Did he use the same certificate for the general elections on the 8th of August? Because it was spent. Your Lordship, I can read it out, Regulation 16. A political party candidate at a presidential election shall be nominated by a political party by and delivery to the Commission on the day fixed for nomination of candidates at that election. At that election. It is not at any other election. It's very specific. But Your Lordship, to give further assistance to the court, Form 20 of the regulations that provide for the certificate specifies that you must state the date on which the election is to be held. That is also provided for in Regulation 51 for the certificate. And therefore, it is our contention that the election held on the 26th of October 2017 was a fresh election. It was not a continuation or a further election pursuant to the elections held on 8th of August. It was a fresh election. And those are the clear words of the Constitution. Your Lordship, it is also a fact, and this cannot be disputed, that all the respondents are aware that nomination was a critical area of the presidential election. And that is the effect of the page I've shown you, because the first and second respondent admitted at length that the nomination was so central to the election process that it would affect the outcome of that election. Having known that, Your Lordship, and having admitted that openly, it was improper for them, it was deliberate, and it was...
Sorry, Mr. Uma.
Yes.
You keep harping on submissions by counsel in proceedings before the High Court.
Yes.
What is the evidential value in these proceedings of submissions by counsel in prior proceedings in a different court where a different decision, in fact, was given by that court?
Yes.
What is the evidential value of those submissions for these proceedings?
Your Lordship, this petition, when the petitioner became aware of the illegal activities, they moved the High Court on the same petition. And the matters were similar, the matters were the same, and in fact the same petition is annexed to these pleadings. Those were, it is the third respondent who are telling us nomination is critical, but this is the wrong forum. Now we've brought them to the right forum, where they wanted us to come. And therefore, that is why Mr. Musyoki was saying that we still hope their position is the same. Because this is something that is given in public, forms part of the public record, and is an admission. Your Lordship, if you were to look at the decision, it was so controlling to the judge's decision that the judge had to down his stool and say that nomination must only be had by the Supreme Court. Yes, that is the importance of that authority.
My Lord, my understanding of the law is counsel cannot make an admission on law. It can only make an admission on facts. So even if my learned friend did make an admission on the law, that is not binding on the court, and the court is still entitled to ascertain what the law is in the particular circumstances.
That's exactly just Sirenaura's question.
Yes.
I mean, counsel could be making an erroneous admission for that matter.
Absolutely.
Yes, it might be an erroneous admission, but when counsel is appearing to court, he's representing the position of his client. When I'm speaking here, I'm an agent of the petitioner. I'm not speaking on my own. And when I'm acknowledging that this is a critical process that can determine the election itself, then I'm representing the position of the petitioner. The petitioner cannot say to not know what I'm saying in court, because he is affected by any decision that I say in court.
Mr. Oma, if you remain faithful to your petition,
yes,
just keep watching the clock.
Yes.
Time will run out before you finish your
yes, I have noted that. Your Lordship, I would wish to reiterate the importance of nomination by citing authorities that have been decided both in Kenya and elsewhere. And the first authority was the case of Karanja Kabage versus Joseph Kiuna that you cited in your decision of the 1st of September, and you stated, and that court stated, that there are certain conditional precedents. There are certain constitutional necessities that are precedent to the conduct of an election. And it gave an example of nomination as one of those conditional precedents. That authority has been accepted with approbation by this court and is at page 37 of our list of authority, the specific admissions. But, Your Lordship, it is also clear that the presidential election is a constitutional issue. And therefore, any breach of that process of the presidential election is a violation of the Constitution. We all know and we all accept that the Constitution is supreme. Nothing, no act, no action can be done that is contrary to the Constitution and that it stands. This has been confirmed by yourselves in the decision of the Speaker of the Senate and another versus the AG at paragraph 51 and 52, and I hope that you will find it of great assistance to you. Similarly, Your Lordships and Your Ladyships, we've annexed the decision of Dr. Kano Kiza Besigye, where the court stated that where there is a substantial departure from the constitutional imperatives for an election, that is not an election, it's a sham election, and the court is entitled to cancel such an election. And to that end, I would want to refer to the decision of Justice J.B. Ojwang in his dissenting opinion, and he says that the Supreme Court is the apex court with the authority to assert the supremacy of the Constitution. So that when we come before the court and we say that the Constitution has been violated, this is the final court with that authority. And I would agree with Justice Ojwang, where he said that we have to draw a correctness or propriety line. What is wrong, we say this is wrong, and the court must uphold it. Your Lordship, the decision for Adford versus Linsky has been mentioned to you, and it was actually produced by learned senior counsel, Mr. Ngatia, to illustrate the essential nature of the election. And then he said, in his own words, that nomination is an essential part of the election. Knowing that it was an essential part, they cannot run away from it. That decision, especially at page 233, is also placed on record for your benefit. Lastly, Your Lordship, if you look at the record, there is, when the first and second respondents were conducting nominations on the 28th and the 29th of May for the elections for 8th of August, one candidate presented papers that had not been stamped by the Commissioner of University Education. He was turned away and told that he could not participate in the presidential election. That seriousness, that importance, shows that nomination is at the fulcrum of the electoral process. And to support that decision, we've annexed the decision of Ratan and Mol Singh and another versus Atmaram, which is a Supreme Court decision of the Supreme Court of India at page 165, where some candidates had people subscribe to the nomination papers who are not supposed to subscribe, and they subscribed in the wrong manner. The Supreme Court upheld their rejection to participate in the election, and therefore it is a fact that the first and second respondents are aware of the importance. Your Lordship, I would wish to re-emphasize that even if you were to go to the issue of the will of the people, as illustrated and as defined by Lady Justice Njoki Ndung'u in her dissenting opinion, that when you look at a nomination, you should look at it from a right-centric focus. The same return would come for the following reason. By closing out nominations, they violated a critical part of Article 38(3) that requires that any person be able to participate in electoral contest for elective positions. In this case, by limiting this to 2 candidates when the elections had been invalidated, the first and second respondents also breached the right of all the other candidates who might have wanted to contest for this office. And some of them have even come to this court claiming that they were denied that opportunity to contest. Further, Your Lordship, the ballot paper must contain only the names of validly nominated candidates. The Constitution under Article 1 says that the sovereign power and the sovereign will belongs to the people. And the people have donated that sovereign power to the state organs so that when they exercise that power, they exercise it in strict conformity to the Constitution. The Constitution requires that only nominated candidates go to the election, and the regulations provide that only validly nominated persons be included in the ballot. By including the names of persons who are not validly nominated on the ballot, the will of the people has been violated. Your Lordship, we need not to put further emphasis on the supremacy of the Constitution. It is the supreme law, and it declares so in its founding articles. The question then would come, do we shut our eyes to these violations? Do we move on and leave these constitutional violations in place? Do we turn our eyes and turn our backs, close our eyes, and say we need to move on? Your Lordship, as I conclude, I would state that the Constitution offers the basic architecture of how we organize our affairs, of how we conduct our affairs as a nation. It is supreme and it must be protected. The moment one article of the Constitution is violated, in the name of necessity or convenience or expediency, then we are going down a slippery slope where people will author necessities. People will create necessities and seem to justify them through the Constitution. It might have a beginning to allow it to end today, but you might not know its end. It is a critical decision. It's a very simple issue, but it is a very critical decision. I would not wish to be in the enviable position you are in, but the Constitution must be obeyed. It is our supreme law, and it governs us all. If we don't have it, then, Your Lordship, you will note in your address to the country that you stated that the greatness of our country is determined by the fidelity to the Constitution and to the rule of law. We will be moving away from that position. We will be falling away by the wayside. The decision is clear, the authorities are there, the facts are admitted, there is no dispute that there was no nomination, and Your Lordship, we ask and we invite you to grant the prayers as sought in the petition. Thank you very much.
Thank you very much, Mr. Uma, for your submissions. Now, Mr. Ndubi.
Yes, my Lord, and Your Lordships.
Let them move and give you.
Yes. As they're moving, I'm only introducing our team. With me is Ms. Julie Soweto Aulo, Mr. Waikwa Wanyoike, Mr. Donald Dare is not in the courtroom, but should be joining us shortly. Jen Lumalas, Sandra Oyombe, Kelly Malenya, Opolo Okelo, who is also stepped outside, Bemi Kanyonge, and Edgar Kavulavu, who are also going to join us shortly. But to commence our submissions, Julie Soweto will begin. Thank you.
Good afternoon, honorable judges. My lords, I will be presenting the petition on behalf of my colleagues. This is a petition that is for Kenyans by Kenyans. This is how my clients would wish to be introduced. The first petitioner, my lords, is a devout Christian Kikuyu from Thika in the president's backyard. The second petitioner is a devout Muslim from the coast. In their own words, one has little formal education, the other, an advocate and a Rhodes Scholar from Oxford. What unites the two petitioners is their passion for human rights and defense of the Constitution. My team has been introduced, but I wish to inform the court that the team that presents this petition is a group of passionate young volunteer advocates who represent the new Kenya against the old. My lords, my ladies.
Against the old.
Yes, against the old Kenya. My lords, today as a country, we stand at the ledge of a cauldron of uncertainty. This court is our last barrier before we plunge into the abyss. 2 presidential elections in as many months later, and Kenya is still at a crossroads. The choice is stark between being another sorry apology for a republic and enduring the sacrifices that purify this nation into the true democracy for which its people truly yearn it to be. My lords, now as in August 2017, this court is the last dam holding back a veritable flood of uncertainty that would engulf the entire nation. Were there to be any questions that our country is indeed governed by the Constitution and the law. This court's judgment on September 1st, 2017, held out hope for this country to keep together and stoked the embers of justice. Honorable judges, our struggles for dignity and personhood are framed by the Constitution. When any forces, however prodigious, challenge our resolve to be governed as free women and men, we are called upon to defend the Constitution. This court is part of the immunity the Constitution designed for itself in times of crisis, such as we face. It is among the last defenses against any and all assaults on the Constitution by all interests, however benign or benevolent their disguises may appear. My lords, the Constitution is the voice of the people. 68% of the voting population at the time of its passage affirmed it as the sovereign will of Kenya. Elections occur in the context of a wider will of the people. So perhaps we'd ask, what does it matter that there is a little fudging here and a bit of cheating there? The will of the people says we shall hold elections by universal suffrage, that those elections shall be free, fair, and credible, that they shall be conducted by an independent electoral management body that is impartial and neutral. These are not my words. They are the will of the people of Kenya. We only beseech you to do your duty, to respect, uphold, and defend the Constitution. Whatever decision this court makes will decide whether we move forward as a great nation, guided by, first and foremost, our fear of God, our fidelity to the Constitution, and by our strict adherence to the rule of law. My lords, it is only in our fidelity to these principles that we can and will give us a framework for orderly and objective relationships between citizens and the country. This court upholds the beacon it raised on 1st September 2017, or apologize for doing the right thing. That is a fact. We, the people of Kenya, are beseeching this court to act again in defense of the law and the Constitution. If we are to summarize our grievances in this petition, it is that the first and the second respondents do not seem to understand the Constitution and the law, or either they do not understand it or they believe they can get away with disregarding the law. The starting point is 1st September 2017, because that is where this court gave its direction: go and conduct a fresh election in strict compliance with the Constitution and the applicable law. We're going to demonstrate that the first and the second respondents did not do this. Lords, a general overview and summary of our submissions will be as follows. On the question of universal suffrage, our Constitution requires that for a person to be elected president, he or she should enjoy the support of at least 50% of the votes cast and at least 25% in more than half of the counties. That requirement presumes that elections are held in a normative context with the participation of as many voting adults as possible. The purpose of these constitutional provisions should be obvious. If a candidate obtains 70% or 90% or even 100% of 1 million ballots, this court must ask itself if such an election conforms to the spirit and intent of the Constitution. It is therefore no wonder that the Constitution also provides that the election of the president must take place in each of the 290 constituencies. In this election, a total of 3,635 polling stations out of the total 40,883 did not record any votes. This represents 1,770,475 Kenyans. Our second submission will be on violence and intimidation. My lords, we have annexed to our documents and shown that there are various reports by reputable organizations, including the government's own Kenya National Commission on Human Rights, recording loss of life, harm to limb, people died, hundreds were injured, scores more sexually violated during the election. The threat to life and limb was clear and present before the polling day and on the polling day. Because of violence and intimidation, people were not able to vote again in 3,635 polling stations. Our third ground will be on the lack of independence of the electoral body. Honorable judges, this court cannot avoid the reality before its eyes, which is that the IBC appears to be under the thumb of the executive, currently controlled by the third respondent. Their pleadings are either similar or complementary. The affidavit of the chairperson is proof that the commission was never independent, but was working overtime to please political players such as the National Super Alliance and the Jubilee Party. The internal incoherence of the commission is proof of its own discordance, brought to light most dramatically by the resignation of Commissioner Rosalind Akombe. My lords, part of the dysfunction of the IBC is right before this court, in the form of the affidavit sworn by the Vice Chair on her behalf and on behalf of 5 other commissioners, excluding the Chair. We will be asking the question, what is to be understood by this? The fourth limb of our submissions will be on illegality. My lords, the IBC seems to have decided what law to follow and what law to ignore. It chose to rely on the Supreme Court decision in 2013, where it provided that only the president-elect in a nullified election and the successful petitioner should contest the fresh election, but it did not obey the direction that one candidate abandoning the race would automatically require a new election. On illegality again, the IBC printed ballot papers with Shakalaga Hua Jirongo's name on the list of candidates on October 19th, and then gazetted his candidature on October 24th, 2 days to the election. It declared that no nominations would be conducted when it could have declared the candidates as having been nominated by dint of the Supreme Court's nullification of the August 8th, 2017 election. Finally, we will make submissions touching on dishonesty and duplicity by the first and the second respondents. My lords, in our petition, we show that the IBC has been unable to tell a consistent story about the elections. The number of registered voters, for instance, is a moving target. The voter turnout in the fresh presidential election changed at least 3 times. It is our submission that voter turnout is the true north of any credible election result, and it is locked down at the close of polling. My Lords, I will address you on the grounds of violence and intimidation and lack of independence altogether. My colleagues, Mr. Wiper will address you on the question of universal suffrage. My colleague, Donald Dare, will address you on the question of illegality. Because of our limited time, my Lord, we will address you on those factors that we consider pertinent to the vitiation of an election, and which this court, if it decides or rules in favor of the petitioner, then the election cannot stand. My Lords, Article 81 of the Constitution sets the principles that the electoral system shall comply with. Article 81E provides that the electoral system shall comply with the principle of free and fair elections, which are free from violence, intimidation, improper influence, or corruption. 81E3, that free and fair elections must be conducted by an independent body. 81E Roman 5, free and fair elections must be administered in an impartial, neutral, efficient, accurate, and accountable manner. My Lords, we have, in my submissions, I will say, we need to look at the environment in which the election was conducted. And I've characterized that in two forms: the external environment, which was marred by violence and intimidation, and the internal environment, which is the environment within which the IEBC was operating, and which we say there was no independence, there was no impartiality, but there was also violence within the environment of the IBC. My Lord, it is our submissions that the question that there was violence before the election, after the election, is admitted. It is not in contest. The fourth respondent has admitted in their responses, the third respondent, I beg your pardon. The third respondent has admitted that there was violence before the election and during the election. The first and second respondents equally admit that there was violence before and during the election. Indeed, my Lord, it is a little difficult to even talk about before the election, because this court has said an election is a process, and therefore everything that happens before the polling day is part of the election. My Lords, we will go no further than to utilize these addresses, the public addresses and statements that were made by the second respondent in our petition. Sorry, he's the first. By the second respondent after the consolidation, which is the chairperson, updating this country on where matters stood with regard to the election, and the circumstances in which they were operating. My Lords, I wish to refer to the statement of address made by the chairperson on the 18th of October 2017. It is found in the first respondent's replying affidavit. It's on the document, it's written, the first respondent's replying affidavit in petition number 4, at page 180. My Lords, this is the Chairman's address on the status of preparedness for the elections, dated 18th of October 2017. The statement comes a day after Commissioner Roslyn Akombe had resigned and sent out a press statement. My Lords, the first thing is that the chairperson publicly admits the resignation of Commissioner Akombe and then owns the reasons she gave for her resignation, and we will come to that. The expressions that she had made when she resigned. My Lord, in acknowledging Dr. Roslyn Akombe's resignation, this is what the chairperson had to say as he addressed Kenyans. She is one of our finest brains, and it is very sad to see that we could not provide an environment for such minds to find full expression without fear for their lives. That is an admission that there was threat to the life of Commissioner Dr. Akombe. Just a minute. Yeah, it's okay. My Lords, in the same statement, at page 181, the chairperson, speaking to Kenyans, says, "With gratitude to God and the Kenyan people that gave me this opportunity, that is why I have now come directly to the Kenyan people, because you deserve to know the state of the country's preparedness for the FPE, which I take to be the free presidential election The fresh, sorry. Thank you. The fresh. Later down in the same statement, he says, "You have a right to know the state of things in our beloved country. I have chosen to communicate directly, also to ensure that you do not get speculative ideas or outright false news from the fake news mongers." This is the chairperson speaking. In the following page of the same statement, it says, "There are numerous calls for peace, but we all appreciate that peace without fairness and justice is an illusion of peace. It is the fountain, credibility is the fountain where true peace flows from. The Bible tells us in 2 Samuel 23:3, "He that ruleth over men must be just, ruling in the fear of God," while the Quran reminds us in Quran 49 that verily Allah loves those who are just. The chairperson is speaking to the environment. Going further on in the same statement, at page 184, the chairperson confirms, and acknowledging the environment in which they're operating, that a leading candidate who garnered more than 6 million votes has withdrawn from the race. While it is his right, we must think beyond him and think of the 6 million Kenyans who will feel disenfranchised by this action. He acknowledges that there are Kenyans who will feel disenfranchised, and then asks a question: do we just go on as if this withdrawal means nothing? Later on, in the same statement, he says, "I want to state categorically that I shall not go down in history as the national returning officer that plunged the country into a further crisis than I had found it. It is already painful to be on record as the chairman of the IBC that presided over a presidential election that was nullified by the Supreme Court." And then he makes the critical points and admission. "I have made this point on numerous occasions to my colleagues at the Commission. I have made several attempts to make critical changes, but all my motions have been defeated by a majority of the commissioners. Under such conditions, it is difficult to guarantee free, fair, and credible elections. I am convinced that without critical changes in any secretariat staff, we may not have a free, fair, and credible election. I ask the staff who have been adversely mentioned to step aside and allow the project team to function without interference." The chairperson, in his address to Kenyans, is admitting, one, there is political interference within the IBC. He is admitting to Kenyans a week to the elections that he cannot guarantee free and fair elections. Further on in the same statement, he says, "As a lawyer, I cannot continue to be pushed by majority commissioners to accept legal opinions that serve partisan interests and are not grounded in the Constitution or the law. In the least, this is intellectual dishonesty for which my professional training demands that I abhor." This is a public admission that there were partisan interests within the IBC by none other than the National Returning Officer. And then, further on, in that same statement, the chairperson says, once there is political agreement as a result of dialogue, when there is genuine commitment to let the commission work independently, when all the commissioners and staff truly commit to serving the country rather than partisan political interests, and when we work together to create a conducive environment for Kenyans to express their sovereign will, then I can truly be confident of having a credible presidential election. The chairperson is admitting publicly to Kenyans that the commission is not working independently. And of course, the question we should ask is, who is he blaming? Who is it that is not allowing the commission to work independently? He goes on to say, as the referee, I want to issue a stern warning to the players of this game on all sides that they should stop all attempts to interfere with the process. Failure to do this will result in consequences. I have made up my mind to uphold the Constitution and the will of the people of Kenya, regardless of threats, intimidation, or pressure. My Lord, the purpose of reading this address to you was that the IBC itself and the chairperson publicly admit the challenges they have, that they do not have independence, there is no impartiality, they are afflicted by partisan interests. And so that question cannot be said to be in contest when they have made public admissions. I had earlier said that this public address by the chairperson came after the resignation of Dr. Roselyn Akombe on the 17th of October 2017, and the first respondent indeed admits in his response at paragraph 48 that Dr. Akombe resigned from the commission and released a statement on 17th October 2017 in which she expressed her assessment of the commission's preparedness for the fresh presidential elections on 26th of October 2017. It's therefore important to see what Dr. Akombe had to say about the commission's preparedness for such election. My Lords, the press statement by Dr. Akombe is found in the affidavit in volume 1 of the bundle of documents supporting the petition. It is annexed to the affidavit of the first petitioner. It's at page 81, marked NM 14. And this is what Dr. Akombe had to say. For many months now, I have questioned my role as a commissioner at the independence, for many months now, I have questioned my role as a commissioner at the Independent Electoral and Boundaries Commission, but I have soldiered on, hoping that we could collectively find a way of addressing the crisis our country faces. Sometimes I have agonized over the decision to leave my committed IBC field staff and my country. My decision to leave my decision to leave the IBC will disappoint some of you, but it is not for lack of trying. I have tried the best I could do, given the circumstances. Sometimes you walk away, especially when potentially lives are at stake. The Commission has become a party to the current crisis. The Commission is under siege. This is an admission, a clear statement of the presence of violence affecting the work of the Commission.
Madam, is that statement hearsay, or is it a statement of truth coming from the person who perceived it?
Sorry, my lord, come again?
Is that hearsay, or is it a statement from the person who perceived it, the person who expressed it and witnessed it, the one that you were giving just now?
The statement is made by Dr. Akombe herself.
Is she the one speaking? Is this one statement by the person who witnessed the situation?
My lord, I'm not sure that I get the question correctly.
The point simply is that there are things which are perceived.
Yes.
And as a matter of evidence, those who perceive them can speak about their veracity. Those who have not perceived them can only relate them as evidence. This is basic law of evidence.
Yes.
I think you need to speak about that.
My lord, this is a statement, but that is written by the Commissioner herself. It is signed by the Commissioner herself as a person who was working at the IBC. As a Commissioner, it would be said she perceived it and is therefore qualified
what medium
to speak.
is this coming? Because that medium determines veracity. This is basic law of evidence.
My lord, this is a written statement on the letterhead.
Can you vouch as to the validity and veracity of that statement yourself or any other person without the owner itself, the one who pronounced it, speaking to that?
My lord, the only evidence that we have is that this statement has been owned by the chairperson and the Commission. It has not been denied. And so we take it as being a fact of what is being spoken and that it actually came from Dr. Akombe herself. It has not been denied. It has not been...
Okay, proceed.
But my lord, I think that, my lord, the point my Lord Justice Ojwang is making, which should form our objection, is that whereas the statement by Dr. Akombe is fairly not in dispute, for that evidence to be brought to this court, who is making that averment? You can't make a statement made by a person and you are not making clear the medium through which you are admitting it or making it admissible evidence. Akombe has not sworn any affidavit before this court. So my learned friends should satisfy the test. Through what medium are you adducing that evidence? Because the veracity of the same, you can't adduce all kinds of statements made throughout the world, and you cannot channel it in a proper manner through this court.
My lords, an inference of truth an inference of truth must be drawn from the fact that the chairperson of the IBC acknowledges this statement, refers to it in his own affidavit. It is part of the documents that were presented, so where there is no denial as to its veracity, today it cannot be claimed that this statement was not been made. It is admitted by the second respondent himself, paragraph 48 of the affidavit. And indeed, the second respondent goes ahead to express his own views with regard to that statement. That in itself shows an admission of this statement by Dr. Akombe. My Lord, suffice to say, the purpose of that statement by Dr. Akombe, which is owned and admitted, or at least the contents, and which is why we started with the chairman's address of the 18th of October 2017, was to show the environment within which the IBC was operating. My Lords, at page, we wish to refer to yet another address by the chairperson of the IBC, the second respondent, to show that an environment of violence already existed before the election and during the election. The reason we do this is because, my Lord, we are seeking to lay squarely at the feet of the IBC the blame that the environment that existed before the poll day was created by them. They were aware of it and did nothing about it, and still insisted on conducting the election on the 26th of October 2017. And next to the affidavit of the petitioner, at page 97, marked NMA 18, is the address by the chairman a day after the election on 27th of October 2017. And the chairperson says, "Fellow Kenyans, yesterday some of my staff were hijacked and some were tortured. Some had their homes broken into and looted. Others were forbidden and violently prevented from reporting to their polling stations and were literally chased away. Some have had to take refuge in police stations. In some instances, even when the police got reinforcement to secure the IBC staff, it did not prevent the violence, as the surge of violence from the protesters was also escalated." This confirms that there was violence on the poll day. Fellow Kenyans, he continues, there are even returning officers and entire polling staff in some of the areas where breach of peace was was reported that have gone into hiding due to the resistance from those who do not want the people to exercise their constitutional right to vote. The question is, was the violence that happened on Poll Day one foreseeable? If the answer is yes, then the question would have to be, could the first and the second respondents hold an election or claim to hold an election that meets the test of a free and fair election in that environment? My lords, from the previous addresses that we have read, it is our submission that the violence was foreseeable. It was already existent. Yet, the first and second respondents chose to go on with the election in that environment. Our Constitution, Article 81E, says an election for a free election to be conducted, it must be free from violence, intimidation, improper influence, or corruption. So if before the election there was violence, during the election there was violence, can that be said to have been a free and fair election? Otherwise, then we also must ask the question, how much violence is acceptable? 1 loss of life? 31 policemen dead? How much would we say is acceptable to decide this is not an environment within which a free and fair election can be held?
Council.
Yes, my lady.
But you want to be specific. Would you like to speak to where that violence was? Was it countrywide?
The areas to where the violence was?
Mm-hmm.
Yes.
Is that relevant?
My lady, I would not say, I do not think it is relevant. It is relevant, yes, that in some areas were affected. However, it is also not relevant that in some parts of this country, an election could not be held because of perceived violence in those areas, whether actual violence happening in those areas. And there are places where we know that the election, even though it took place, there are people who stayed away because of fear of violence erupting in those areas. But the reason why I do not think the question of where the violence happened is relevant is because the election is required to be conducted in all 290 constituencies of this country. We are one country. To say that we are only going to conduct an election in some parts of the country and leave out other parts because in those parts there is violence is to divide this country. It's to balkanize this country. Then are we saying, and my colleague will come to argue that, because then that question affects the right to universal suffrage. Are we then saying because we cannot hold the election in those parts that are affected, they do not count as Kenyans?
You're doing exactly what I wanted you to do, which is to address the effect of that violence, wherever it was.
The effect of the violence, my lady, wherever it was to deny a chunk, a large population of this country, the right to exercise their right to vote. And that right is exercised in the context of a national presidential election. Part of Article 81E, and our argument is that the principles in Article 81E are not separable. They must all be present for a proper election to be conducted.
I suspect this is something that Mr. Waikwa will probably address.
Yes.
But I hear you focusing on the rights of those citizens who did not vote in violent-prone areas. Will you be addressing equally the rights of those who had the right to vote where there was no violence? And how then the IEBC was to balance between the two? Because all citizens are equal, everyone had the right to vote, there are those who could not, there are those who could.
Yes.
So are you going to address and that the issue of balance on that issue? I suspect I know, probably, Mr. Waikwa, but I would like you to also address it as you speak.
Yes, Maluri, and I will address you on that right away, and which is why I laid the basis and said there were two environments. There's the external environment, and then there was the internal environment. The internal environment of the IEBC, we say, is what precipitated the external environment. Because the IEBC could not conduct itself in a manner that fostered a free and fair election, one of the things that then happened is that those who were aggrieved in certain parts of the country decided they will boycott the elections, chose to exercise their rights under the Constitution, whether to demonstrate or to picket, which led to violence before the election. Now, when before the election, violence has already manifested itself before the conduct of the election, and this is affecting other parts of the country, and the IEBC is aware that in some parts of this country, they will not be able to deliver an election that is free from violence, can they then hold an election a presidential election for the entire country, meeting the requirement that it must be held in 290 constituencies? If in the part where some people or other parts of the country where people do not want to vote, and then there are those parts where people want to vote because equally they have the right, but they equally enjoy the right to universal suffrage. My lady.
Please, could you address one thing here? This Supreme Court ordered that elections were to take place within 60 days.
Yes.
So that was the law.
Yes.
That law also required just one agency in this country, set up under the Constitution, to conduct those elections. Could those responsibilities have been passed on to someone else?
My Lord, the responsibility is on the IEBC. But in reading the Constitution, we must read the Constitution holistically and not disjunctively. When reading the Constitution, our argument is that whoever, and this applies to the first and the second respondents, in interpreting the Constitution, they must apply all the principles of the Constitution. Article 140 applies with the same level as Article 81 of the Constitution. My Lord, the argument and what you're presenting is a false legal dichotomy that we believe the respondents will try to present to this court, that we have to have a choice between holding an election within 60 days, the timeline created by the Constitution, and holding an election that meets constitutional muster. Our submission is that both must happen. You do not have to choose between one or the other. There is no contradiction in the dictates of the Constitution. Whenever any question calls for interpretation, we know what our values under Article 10 are. It was incumbent upon the first and the second respondents to consider within the environment within that they're operating, under all the circumstances, are they able to meet all the prerequisites of the Constitution? My Lords, under Article 10 of the Constitution, we say these are the national values and the principles of governance that bind all state organs, state officers, public officers, and all persons whenever any of them applies or interprets this Constitution, enacts, applies, or interprets any law, makes or implements public policy decisions, and those values include patriotism, national unity, sharing, devolution of power, the rule of law, and democracy and participation of the people. They must also encompass human dignity, equity, social justice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized. Additionally, they include good governance, integrity, transparency, accountability, and sustainable development. We must ask at every stage the decisions that were taken by the first and the second respondents, do they meet the aspirations of Kenyans? Were those decisions that could bring about the free and fair election that they were expected to conduct? My Lords, this court being the arbiter of matters relating to the presidential election, or whenever we have difficulties, it was open to the IBC to come before this court and say, we are facing a challenge. You have ordered us to conduct an election within this time frame, but we have a challenge and we need help. The chairperson came to this court to argue numbers before the election. Why did he not come to seek clarification if there were challenges with regard to holding the election, an election that would meet constitutional muster under Article 81E? It is for, my Lord, again, it is for that reason that we actually say it was foreseeable with the reports that had been made by various organizations, national institutions. The first and the second respondent could not say, they could not foresee the difficulty or the challenge in holding an election that met all the principles under Article 81E, under Article 1 of the Constitution. It was not for them to decide whether some Kenyans get the right to universal suffrage and other Kenyans get an election that is free from violence, intimidation, improper influence. All these factors must be present at the same time for the same election. My lady? Again, my Lord, it is not for the duty to ensure the environment or the electoral system is on the IEBC. That duty is placed squarely on them, not on any other body. So it is for them to make the determination as to whether they are able to comply with the principles provided under Article 81E of the Constitution. My Lords, in the address that was made by the second respondent, the chairperson, one day to the 26th of October, 2017, the chairperson is still asking questions. In fact, he says, I have never heard of a nation where one day to the scheduled date of the election, the question on the lips of everyone is, will there be an election? He was alive to the facts and the environment within which he was operating. On the 25th of October, he says, I have watched and heard of terrible things that Kenyans have experienced in recent times in the hands of the police who are enjoined to protect them. Fellow Kenyans, excessive use of force by the police is not an illusion. It is the dark reality that some people have unfortunately had to experience in recent times. When the very people that we are expected to run to in times of trouble are the ones attacking us, then as a country we are at our lowest. The innocent Kenyans who have signed up as staff of IEBC to serve their nation never for 1 minute expected that the job would be a risk to their lives. Only last week, the house of one of my staff was burnt down to ashes by people who, up till a few weeks ago, were friendly neighbors. When your decision to serve your country at home in a hallowed responsibility of midwifing democracy becomes as risky as going to war, then we are at our lowest. He's confirming what he already knew. And then the day after the election, he comes back and says, the houses of my staff were burnt. And proceeds to conduct an election within this environment. What then is the meaning of an election free from violence and intimidation? My Lords, on 30th of October 2017, again, the chairperson confirms in a statement, it is in his own address, at page 195 of his affidavit, replying affidavit, he says, sadly, ladies and gentlemen, we must recognize that some of our members of staff lost their lives and property in the course of their duty in the 2 presidential elections. Regrettably, innocent children, men and women have lost their lives and property. Many have been injured or maimed, all in the midst of political competition. It is a submission that it does not matter who created the violence. It is sufficient that it was there and that it marred the election that was conducted on the 26th of October 2017. And for that reason, it cannot stand. It must be vitiated. Finally, my Lords, I will take I will take 5 minutes to address the question of what we have termed dishonesty and duplicity by the first and the second respondents, which is borne out by their own documents. My Lords, in the first respondent's replying affidavit, at paragraph 48 and 49, we have shown that the second respondent, the chairperson, admitted, owned the things that were said by Commissioner Roslyn Akombe, acknowledged them to be true, and then in his own affidavit to this court, he comes back and says that the views expressed in the said statement were the Commissioner's individual views and that they do not represent the views of the Commission. Yet he came and acknowledged them before Kenyans. He says, I further, at paragraph 'I beg your pardon, just a minute. At paragraph 51, he says that he decried the unfavorable environment owing to the political influence on the second respondent in the conduct of the fresh presidential elections, and then goes to say that he did not cast doubt on the second respondent's preparedness and ability to deliver a valid, fresh presidential election. Yet, in his own words, he expressed that doubt. So there is dishonesty where, when it suits him on one moment, he says one thing, and with another breath says something different. My Lord, in his own affidavit, again at paragraph 62 and 63, he says that in the preparation and conduct of the fresh presidential election, he admits the commission faced serious security challenges, including threats to its staff and infrastructure. Other commission processes, including trainings and deployment of critical election materials, were violently disrupted. He admits that. He further admits that there were security threats in 25 constituencies, which led to the postponement of the poll. Somewhere else, in his own affidavit, he says that those matters did not affect the poll or the election. That is two-facedness. That is dishonesty that cannot be the character of a leader.
Counsel, that being the case, which part of this evidence do you want to rely on, the dishonesty part or the earlier part? Because you can't advance both. You've got to choose whether you want to rely on the first one or where, according to you, there's a turncoat.
Malini, the character
May I just add something to that? You see, the court must depend on firm and stable evidence. And so there's that evidence which is sworn. It comes in the form of formal depositions. You have cited both types. And you seem to attach more weight to the general part, which is not sworn evidence, but you're not attaching significance to the sworn part. But the court must depend on the sworn part rather than the unsworn part.
My lords, actually, the sworn parts do confirm what we are saying. We're just saying that even within his own affidavit, he speaks with both sides of his mouth, because it is in his own affidavit that he's acknowledging.
Actually, that's my issue.
Yes. Yes.
So what? So what? So what are you left with? What do you want us to take? Do you see where I'm going?
So he's dishonest, so he's double-faced. This petition is about the validity of a presidential election. Take us there. What does that mean to the issue before us? He's a chameleon. Yes, he may be. What about the petition before us? How does it affect the validity of the election? Take us there and save on the time.
My Lord, I will answer the question and wind up on that so that my colleagues can deal. It affects the validity of the election in this way. By confirming himself that he could not hold a free and fair election, or by confirming himself that there was violence, the principle under Article 81E was not met. And where that principle is not met, we do not have a valid election, even without looking at any other principle. That is what we're saying. Thank you.
Honorable judges of the Supreme Court, my name is Waikwa Wanyoike. I'll be presenting primarily on two issues. I'll present on the issue of universal suffrage, and I'll also present on the new Election Laws Amendment Act, but specifically what does it mean to have what Parliament would want to tell us is a new Section 83 and the impact to the determination the court will make. Just quickly before I proceed, I just wanted to point to the court in regard to a question posed by Justice Ojwang on evidence, that for purposes of the record, may it reflect that question that was posed in terms of admissibility of the evidence from Dr. Roslyn Akombe. We are relying on Section 33B of the Evidence Act, and we are saying that whatever information my lead counsel was referring to was information made in the ordinary course of business. But I'll leave it to the court to look at that. The second thing, just before I get to my arguments, just for purposes of the evidence on violence, we would also invite the court to look very, very closely to a volume filed by the second respondent relating to affidavits prepared by returning officers from all those constituencies where election never took place. May I then move to my submission? I'm hoping I'll be within time. I'll do my best. And again, sorry, I should say this because this is important for the court. In terms of, and again, because we don't have much time, in terms of the authorities we are relying on, we have filed a case digest. That case digest contains over 100 authorities, a list of 5,000 pages of authorities. We realize how overwhelming that is. We've also filed an electronic copy of those authorities, and we've highlighted in the electronic copy the sections we want to rely on. So where I may not be able to go to the authorities, then I would refer the court to those. May I start?
Just before you start, I'm just interested in, I don't know whether this is a new style of citing authorities, where you file a case digest, 100 authorities, you throw it to the judges, say plow through that, you will find your way. Because the best way to go, the way I know and you know, is that when you're making a submission, you support it with an authority. And it is for you to point at the case digest, say go this page, at this paragraph. But for you to file a case digest and say plow through that and you'll find your way, it might not be very helpful.
My Lord, I hear you. I also hope that the court appreciates that we're working also under very strict timelines. So to the extent that I can, and to the extent my colleague will, we will do that. But we've also tried to be as of much assistance as we can be to the court. In fact, I should point this out. The digest itself not only puts the page numbers where the authority is, it points the page in the authority where you will find the specific references. Yes, Honorable Chief Justice.
That is why, Mr. Waiwa, I told your friend, I think it was Mr. Uma. Is it Mr. Uma or Mr. Musyoki? That when you are making a proposition in respect of which you have an authority, cite that authority at that point. So that when we look at the answered report, we are able to go to the report you're citing and see how it supports your argument.
I'll do my best.
Don't argue until the end and then you tell us, I rely on these authorities. On what point?
I'll do my best. And in fact, just for the benefit of the court, we actually have categorized in the digest the authorities based on the themes. If I may proceed, I'm getting a bit worried about my time. The starting point in the universal suffrage issue is to ask the question, who is a president? And who is a president in the context of Kenya's constitution? And to answer that question, we go to Article 131E. What does Article 131E say? It says that a president is a symbol of national unity. And in assessing the validity of this election, then you must assess whether in fact the aspiration given to the office of the president under Article 131(1)(e) has been met. But what does the president do? That is my second question. The president under Article 131(2) promotes and enhances unity of the nation. So then the question for the court is, which nation in the context of October 26th election? And did the election take place in the nation? Then the third question, where does the election of the president take place? And if you go to Article 136(1), then you find that the election of a president takes place as a form of a national election. These are important principles. And I would refer the court even to the preamble and the kind of nation that the preamble recognizes. So what is a national election? And that is Article 138(2). And 138(2) says a national election for the president has to take place in all the constituencies. 290. Now we have 291 because of the diaspora. So is it a presidential election under Article 138(2) if it's not taken place in all the 290 constituencies? I think that's a question the court will have to determine. Then I move on to ask, how does it happen? How does an election of the president happen? What does the Constitution say about that? And we start with Article 138(3)(a). In terms of the extent of entitling every registered voter to vote. entitlement. So anybody who wants to vote should be given an opportunity to vote. Then the question becomes, did everybody who wanted to vote on October 26th vote? Is that a violation of 138(3)(a)? And I would also want to refer the court to Article 81D. What does Article 81D say? Because now, once we get to 138, now we start talking about the universality or the universal suffrage concept. 138D says, the electoral system shall comply with the following principles, and D, universal suffrage based on the aspiration for fair representation and equality of the vote. And may I pause here and say, the Constitution doesn't anticipate or expect our election to be about a winner or a loser. The Constitution expects that people vote as a means of expression. If it was about losing and winning, some of the candidates who have been participating would not get a single vote. So that becomes a critical consideration. And in terms of Article 38(2) also bolsters the concept of universal suffrage. When you look at the quality of election that is expected under the Constitution, you go to Article 81E. And what does Article 81E say? It says it has to be a free and fair election, and then outlines the elements of what a free and fair election is, including free from violence, intimidation, improper influence, and my colleague has already handled that. We may want to ask, what is universal suffrage? We are talking about universal suffrage. What is the definition of universal suffrage? Universal suffrage just simply means the opportunity for almost every adult citizen to vote in a political election. That's what it means. So, in my submission, I submit that beyond the Constitution, this court has to look at the international instruments that we are party to. And I would refer the court to our written submission, but emphasize among those is the Universal Declaration of Human Rights at Article 21 and the ICCPR at Article 25, in terms of contextualizing this concept of universal suffrage. I don't want to dwell a lot on what is a free and fair election, because I think in terms of answering the question of universal suffrage, you will have to ask yourself, did every adult who wanted to vote, vote? You will ask, was what was organized on 26th a free and fair election? And was it an election that allowed for the free expression of the will of the electorate? When my lead counsel submitted, she dwelt a lot on the issue of violence and intimidation. But is that the only issue that vitiates the election of the 26th? It's not. In fact, one of the primary issues is turnout. Turnout. Just the number of people who came out to vote. What was the turnout? And when you retire, this is in volume 2 of our documents. IBC's number, 38.5%. 38.8%. Let's make it 39%. What was the turnout in August 8th election? 79.5%. So we make it 80. Why was this turnout affected? The simple answer you might get is because of violence and intimidation. But that doesn't tell the whole story. The whole story is that there was lack of trust on IBC. Why? Because in areas even where there was no violence or there is no evidence of violence, the turnout was still very low. Let me just illustrate. Makueni, what was the turnout? 4.6%. Do we know of evidence of violence relating to Makueni? What was the turnout in August 8th election? 78.8%. Nyeri turnout 84.2, but it was higher by 2 percentage points in August. Meru 63%. In August it was 78%. Wajir 19.4%. It was 73%. I can do this with every of these counties. So the question then is, in these places where there is no evidence of violence, what do we attribute that to? And in my humble submission is that there were other factors as submitted by Ms. Soweto that affected turnout and vitiates the election. Why is this important? Because it speaks to whether the turnout confirms the president being a symbol of national unity. Whether the turnout confirms that there was universal suffrage. And if I just may make one anecdotal point on this, even if you were to eliminate the 1.7 million in places that were seriously affected by violence, what do you end up with? You only end up with about 42.2%. And you contrast that with the 80% in August. So we also submit that the denial of all the cancellation by the IBC in 25 constituencies also affects the question of suffrage. And the first issue is that when you go to Section 55B of the Elections Act, you don't find anything speaking to cancellation. So cancellation in itself was illegal. And again, tying to the point that you don't just vote so that your candidate wins. You vote sometimes to express yourself. And so, even assuming cancellation can be found to be supported somehow by law or directives, is it a reasonable limitation? And we submit it's not. Because the worst that it does is to lower the dignity under Article 28 of those who are not given the opportunity to vote. You're just simply saying your votes are less deserving. Yes, you pay to the pot of 12 billion to organize this election, but no election for you. Let me then sum that up and say, in our submission, when you look at the entirety of the context, not only was violence important in terms of showing that this election is vitiated, but in terms of the number of people who are able to vote and the reasons why they couldn't vote affects the election. I notice that I may be running out of time, so I want to go to Section 83 of the Elections Act. And may I start by...
Sorry, before
Yes.
before we go to the next, that's a different subject.
Yes.
I still don't think you, I asked a question earlier, and I was hoping that you would address it, about the rights of those who voted and the rights of those who didn't vote. And you may want to address this on the right not to vote, because the right to vote also comes with the right not to vote. You can exercise that right as well. So if you can categorize for us, there's universal suffrage, there everybody registered to vote, there are those voters that were able to vote where there was no violence. There are also those voters who chose not to vote where there was no violence. Then there was, where there was violence, they were not able to vote. So there are different categories, and also one can exercise not to vote. So how, on a point of balance, would you then suggest that you don't hold an election where people can choose to exercise not to vote?
I think I would want to answer that. I'll try to explain that in two ways. The first is the right not to vote. And my submission is we have to look at the circumstantial evidence and ask ourselves, is it that all of a sudden about 50% of Kenyans who normally vote, and by the way, the comparison should not just be between August 8, 2017 and October 26th. If you go historically, what the turnout has been. So is it just because they didn't want to vote? Or is it because they did not want to vote because there were other factors, as explained, including the independence of the commission, that affected their decision not to vote? And my submission would be, when you look at that circumstantial evidence, then it is clear that these factors that we are submitting to court affected the turnout and affected the decision by those people who did want to come out and vote. The second point on this is, when you look at the information that was going out in relation to intimidation of voters, in relation to the fact that a candidate had withdrawn, how does that also affect the ability of people to make that decision not to come out and vote? And so in our submission, it's cumulative. But circumstantial evidence shows that it wasn't based on the fact that people just decided, this time, everything is right, I will not come out and vote. I want to go to section 83. And just to sort of give context to that, and we have this in the affidavit of John Jomue, we have provided information on how a new Elections Law Amendment Act came to be. In fact, there is an affidavit of the leader of Jubilee Majority, which also explains that. But our submission is that that amendment, the law itself, was ill-conceived, first to defeat what this court had decided after August 8th, but more importantly, calculated to affect how the court should determine, or the standard the court should use to determine this October 26th election. And in our submission then, we are saying that because Section 83 becomes central, and we've seen the submissions of the Attorney General, we've seen the submission of the third respondent, they are saying Section 83, as currently amended, is the applicable law. Then the question is it? And we submit that it's not, first because of the issue of retrospectivity. the event that has led us here happened before the law took effect. When did the law take effect? November 2nd. When was it assented? October 28th. When was the election held? October 26th. So it should not be used as a basis of assessing.
My Lord, with profound respect, I think we have to remain truthful. We have to try and be candid with the court. To the best of my knowledge, that law did not become law because of presidential assent. On the contrary, it is by operation of law. So it wouldn't be good to come here and make a bold statement that it received the presidential assent in order to become law. Number two, my Lord, before my learned friend resumes, it's quite clear that the law became law after the elections, and it cannot have retrospective effect. So we shouldn't waste time on matters that will not help the court to deal with the issue before it.
Unless all the parties are conceding on this point, then that the standard applicable is the standard that was enumerated by the Supreme Court in its August 8th, or the decision from August 8th, then I wouldn't push it. But as I said, I've seen it being argued in the third respondent's memoranda.
Mr. Waikwa, just continue. You are giving us your grounds. You said first?
Yes, retrospectivity.
The next?
Yes, and I hope Council doesn't interrupt me again. You know, some of us are still trying to overcome nervousness when we make presentation in this forum. But before I go to that, it's important that I should have wrapped up my universal suffrage argument that really at the end of the day, the legal duty to ensure universal suffrage is on IEBC. That is the mandate of IEBC. So the first argument is that it doesn't apply because of retroactivity. And I just want to go to the authorities. I would refer the court from page 63 of our case digest, where we discuss issues to do with Section 83. The second is that even if it applies, it does not really matter. Because when you go to your decision in Raila Odinga, specifically paragraph 194 and 212, what you are doing is not just to look at the constitutionality of Section 83 as it was. It's to explain what the Constitution requires a Section 83 to look like. Because Section 83, as the court has said, would be a normative derivative. So it must meet the constitutional master. And so, even taking into account that now they've changed all to and, it doesn't matter. The court, when it reads it, it has to read that and as being a disjunctive test. And I will refer you to the authority of Morgan versus Simpson, because that concept has been discussed there. But in any event, we submit that this court can just look at that section, and this ties to my other point, in terms of application. In applying that section, what meaning do you give it? Because the court can either look at a provision on the basis of application or interpretation. And we are inviting you to use your application jurisdiction. But finally, and this is again in the alternative, in the extreme that you still find that it's applicable and the plain meaning should be a conjunctive test, I would submit, because this is so intertwined to the determination of this petition, that you should find that section unconstitutional. I know the respondents say there are cases pending in the High Court on this issue, but it would be unjust for the court to use an unconstitutional provision which is so central in the determination of the matter without pronouncing itself. So, as I close, and if I may take 1 minute, there is in our petition, you'll find that one of the issues that come out in terms of illegalities is whether the withdrawal of Honorable Raila Odinga and Honorable Kalonzo Musyoka, what the effect of that was on October 10th. And we are submitting that if you read Raila 2013, paragraph 290 to be precise, you will see what the court said about the effect of withdrawal. And it means that if a candidate withdraws, then, and they are the only other remaining candidate, you have to have a new election. At the time of withdrawal on October 10th, there were actually only 2 candidates because the decision of Justice Mativo was given on the 11th. And while the respondents argue that he should have filled out Form 24A, we submit that that form only relates to the issue of nomination. And the irony of all this is that if a form is not required to be filled for nomination purposes, why should it be required in the context of fresh election? Why should it be required in the context of withdrawal where it's not expressly provided? I just want to end by just sort of bringing the elephant to the room. And the elephant that is out there by Kenyans or with Kenyans. And the question is, can the court really nullify the election a second time? That's whether we like it or not, that's what Kenyans are asking. And they are saying, or some of them are saying, that because we've been put through this rigorous, circuitous, and very sort of stressful cycle, can the court really nullify? And my submission is that it can and it should, because this court does not work from public opinion, it works from the law. And when you look at what the Constitution requires, we are saying that the Constitution requires that this election be nullified. They're asking, and this will be my last point, who can afford another election? But the question then I would want to pose to the court is this the election you anticipated when you nullified the August 8th election? Did you anticipate an election with a 38.8% turnout? Did you anticipate an election where the presidential candidate in today's Kenya wins with 98.8%?
Mr. Waikwa, when this court issues orders, it doesn't anticipate such things as you are putting to us. We were not political actors. We acted as the Supreme Court of Kenya and issued an order that elections be held within 60 days. So for you to pose questions of percentages of turnout to us is absolutely unhelpful.
May I rephrase and say, is this the election then the Constitution anticipates under Article 38 and under Article 81E. Can we afford another election? And my submission is that this is not the election the Constitution anticipates, and yes, we can and must afford another election, because if we don't, then it renders the provisions relating to free and fair election in the Constitution meaningless. Unless there is any question from the bench.
Yes. Is your concern in that regard just the percentage of those voting? Is that the main concern that you are addressing your mind to? I'm asking that because if you have done some reading outside the field of law and gone into the politics of elections, you'll find that if you hold a series of elections, one after the other, the voters get less and less and less. It is called voter fatigue. And there's nothing you can do about it, whether in America, whether in England, wherever. That one has been proved. So you need to address that.
Yes, Honorable Judge, I do accept your point of fact that numbers will tend to dwindle as you go down or as you do more rounds of election. In fact, maybe that can be attested through by election. But that's the first response would be, but can we expect a dip of 50% just within less than 2 months? Can we, scientifically? And the follow-up question is, why the dwindling percentage? And that is what my colleague answered when she was talking about violence, intimidation, and it's what I was trying to answer by showing that the turnout was not only affected by violence. And maybe just to pause here and ask, if this had been a parliamentary election where maybe 4 of 10 wards in a constituency did not vote, would the court say it was a free, fair election? If it was an MCA election, would the court say it was a free and fair election? I'm just posing, wondering about that, because these and other factors really do affect why the turnout was so low and lend us the aspect of universal suffrage not to have been met.
What you say?
Sorry, Madam Deputy Chief Justice.
What you've just said and the reasons for not voting. And you've taken a while, and your lead counsel has also taken a while to say why people who didn't vote. So the two must be read together, right?
The why and
whether one would call that a credible election.
Yes.
And why certain people didn't vote would have to go together, right?
Yes, and my response to that, Madam Deputy Chief Justice, is to say, in fact, the why is what makes the election not credible. So when you look at the two, when you ask why didn't the people vote, then you're pointed to the evidence why. And that evidence have to be assessed on a balance of probability, and I would submit that the test has been met. May I, Honorable Chief Justice, on behalf of my colleague who is coming up, just request an additional 10 minutes, also because of the question coming from the bench. Yes. May I just make that request?
Very well.
Thank you.
Council on record, your lordships, Chairman Honorable Maraga, ladyships. I will take up this discussion or the arguments or submissions from where we left, from where the discussion was, which was that following your ruling, your orders and directions on 1st of September.
Council, please remind us your name for the record.
My name is Lumalas Yunus.
Sorry?
Lumalas Yunus.
Lumalas.
Yes.
Proceed.
Thank you. I would like to just to briefly take you from where you left, the full stop after your last orders that elections be held in strict compliance of the Constitution, election laws and regulations. And what I'm going to just illustrate are a few irregularities or illegalities that are so fundamental and fatal that would make us not proceed with a different result other than nullification of this election. Lordships, after your orders on 1st of September, what happened is that the first and second respondent acted in total defiance and contempt by actually undertaking an election that was in complete abhorrence of the Constitution and all election laws and rules, as outlined in the petition and in the affidavits accompanying the petition and in oral submissions of fellow counsel. I will start by basically taking you very briefly, because of time, to what occurred on 5th of September this year. Now, if you look at volume 1 of the petitioner's evidence, you will find a gazette notice issued on 5th of September, which is number 37. Now, in that gazette notice, you will see that the first and second respondent are now moving forward after 1st of September. And what they're saying is that following the judgment, we are proceeding with elections on 17th. And what we are going to do is that there shall be no nominations, and this is very crucial for this case. There shall be no nominations for candidates participating in the fresh elections. And that's pursuant to the decision of the Supreme Court. We shall only be having 2 candidates. This they put in their gazette notice number 8751. Okay? And when you look at this same gazette notice, they are saying that pursuant to the decision of the Supreme Court in petition number 5 of 2013, that's why we are having 2 candidates only. So they go ahead and proceed with the 2 candidates in clear understanding that we are having only 2 candidates and we are using the law in place, which was the 2013 Supreme Court decision. Now, under this law, Your Honor, you will find that the term, lordships and leaderships, you'll find that the term fresh evidence has been used. And the legally fresh election, has been used. And this term was pursuant to the invitation of that court by the perpetual amicus curiae to try and, who is my former pupil master, to try and define and give a legal interpretation to what happens with the fresh elections. And what happens thereafter is the only law that we can find anywhere in the Republic of Kenya as we speak on the legal import of fresh elections and what happens after abandonment. You will not find this anywhere. You will not find this in the Constitution. You will not find it in any election laws. You'll find it in this judge-made law that when you look at the petitioners, where is it? I will just direct you briefly to our authority number 42, where that is defined. And the court poses. Suppose, however, that the candidates or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date. What happens thereafter, it is very clear, and this is the law that you'll find anywhere, is that the provisions of Article 138 ensue. Those provisions, under those provisions, we cannot escape nominations. Okay? The withdrawal or abandonment, because Senior Counsel Ngatia was trying to drag this honorable court into the array of politics by trying to distinguish the two. However, abandonment or withdrawal, so to speak, was occurred on 10th of October. When you look at the letter from the candidate who abandoned the election, and that is found in '49. You'll find it on page 49 of the authorities, volume 1 of the evidence of the first petitioner. This letter is of interest, and I would request that this honorable court, when it retires, has a look at the wording of the letter and of the press statement by the same party with respect to the elections. And they say very clearly that they are abandoning the process in pursuant to the 2013 presidential election. So there was clarity as to what law was applicable, and that law was the 2013 Raila decision. So they abandoned the process pursuant to that decision, and that is what they said, which is a legitimate expectation, having been guided by the IBC first and second respondent, that is the actual law in place. Okay?
Now, Madam, can you say something about the express orders of the Supreme Court requiring elections? Can you just disappear and ignore the possibility of the election without coming back to the Supreme Court, when the Supreme Court has spoken very clearly and said in 2 months' time, ensure that elections take place? You come back to the Supreme Court, or you take your own decision and proceed?
What we are saying is that as a nation, we must accept to be bound by the law. Otherwise, even the suits we wear to come to the Supreme Court will mean nothing. Because when the Honorable Court in 2013, and I've directed you to where the authority is, stated that, and this is law, because it has been argued, and you will see it in the responses by the second and third respondent, that they are arguing that once a person withdraws, then the provisions of Section 52 of the Elections General Regulations, as amended in 2012, apply. Okay, but they don't apply, and that is why, if they applied, Senior Counsel would have gone to the next section after that, which is 53, which says, then declare the remaining candidates as the president-elect. Why didn't they do that? Because they knew those sections do not apply. Because what applied is where I've directed you, which is the provisions that flow after, under Article 183(8)(b, then ensue, which means that that other election would stand voided, and we start a fresh process. That is the law. Like I said, there's no other place you'll find that law. And therefore, once that had been done, the IEBC should either have stopped and started afresh, or maybe come for an advisory opinion before this honorable court. But they did not do that. You will find that Mr. Bwana Chebukati, maybe I should call him the first respondent, on 18th of October. When you look at his own affidavits at page 184, he goes on to make a statement, Your Lordships and Ladyship. What he does, he says that a candidate who has garnered more than over 6 million votes, at page 184 of his affidavit, withdraws from an election, which is an admission. Do we just go on as if nothing has happened? He says this 1 week after the withdrawal of from a NASA presidential candidate.
So that you don't succeed in completely losing me, because I think you will need me, and because the lead counsel said exactly what you're saying, I'd like to know the point you are addressing. Are we dealing with illegalities, irregularities? What are we dealing with?
What is
your
with
submission on?
This is still illegalities, but I was highlighting the legal import of abandonment and directing you to the evidence.
So why don't you restrict yourself to your subject? Forget about reference to counsel, please.
Well advised, Your Honor. So basically, I was highlighting an admission by the first respondent and an acknowledgement to that withdrawal, which then brings in the doctrine of estoppel. Other than that, Your Honor, I'd like you to just, maybe just in a minute's time, take you to the question of legitimate expectation. And the submission here is that the forceful insistence on having a candidate who was withdrawn on the ballot paper was actually misleading, and it is our submission that that is a violation, and a violation of the legitimate expectation of the people of Kenya and of the candidates who are participating in the election. And hence, part of the reasons we had the turnout we had. And we'll direct you to some authorities we have in our submissions. You will look at, where was that? Well, we have attached authorities on legitimate expectation, Your Honor. Sorry, Ladyships and Your Lordships. At page 43 of our authorities. You may have a look at that when you retire. The next issue and the next illegality we'll deal with is the question of participation. It's even the decision to use the ruling in the Mativo case to apply and include other candidates in the electoral process. That was in itself illegal because that ruling, 471 of 2017, was in personam. It only affected, when you look at the ruling, it only affected one candidate, who was Mr. Ekuru Okot, and did not affect all the other candidates. So what authority, what law was used to introduce the rest, to the rest? There was no law that was used. It was arbitrary and unlawful.
How does the inclusion of the others affect the election?
Now, when you look at that, which is where I was going next, there's the question of time to participate in elections. We have authorities to show that, including the case of BCJ, that an election process can only be valid when each process is given adequate time. So when you introduce candidates 2 days before closure of the time for campaigns, what are we doing? Are we really having a contest, an election? Are we giving the people of Kenya adequate time to choose and give them right information to pick a candidate of their choice? In my view, it is not a contest. You cannot bring other candidates 2-3 days before elections and another one, no period for election, and the different times, and then you call that an election. It is not an election. That is the submission. Perhaps just to finalize, because of time, I will deal with the issue of another illegality, which was having returning officers appointed on 12th by Gazette notice without having public participation, as is required under Section 3(2) and Article 10 of the Section 3(2) of the Election Petition General Rules 2012 and Article 10 of the Constitution. So that was unlawful. There was no public participation and no participation by political parties as is required by the law. Finally, we have misuse of public office and use of government resources in a way that influences the outcome of the election. So when you look at that, I will direct this Honorable Court in its own time to the affidavit of Joseph Abonga, which affidavit actually confirms what is in the petition of the petitioner, Mr. Njonjo Mue, where it refers to utterances by one, the CS Matiangi. And I would really, even though we are hard-pressed, I would really request this honorable bench to have a look at the affidavit of Karanja Kibicho, which is very, very interesting and amusing to read. He does give us a lot of answers about what happened. He details intimidation to the court, which intimidation was not innocent. It was geared towards influencing the process we are in, which process is also part of the electoral circle. He details, when you look at paragraph 16, paragraph 26, he details what utterances were made. And Mr. Josephat Aboga actually places the CS to the scene of the utterances and it gives its input. Because of time, I'll direct you there. Yeah, so I think in general, all the violations as detailed should only guide this honorable court to have one question in their minds as you sit there, as you try to determine this petition. You all need to ask yourselves whether, looking at the totality of facts and law, was this election, in simple words, was this election undertaken on 26th of October similar to the one of 8th October in terms of compliance with the laws and the Constitution? Was it better? Was it worse? So that if you find that it was actually worse, looking at the petition and all the supporting documentation, including responses that are in support of the position, then you must be able to invalidate the election.
And if we find that it was actually better?
That is the question I'm asking, that you do after totality of evidence and facts, I suspect it was not.
Mr. Lumala, exactly. You have 10 more minutes.
My minutes are over.
Yes. No.
No, we were
it was added here.
We were added, but we...
I will donate to Don.
We have Don Dare to conclude.
Thank you very much, my lords, my ladies. My name is Donald Dare. My lords, my ladies, in the little time left, I'm constrained to speak about just one issue, and that is the irregularities. The irregularities that the petitioners contend and aver were visited upon the election of 26th October. And these are found in their petition, starting at paragraphs 21 to 23, and also at 105 to 133, and in a number of affidavits, especially that of Billy Atudo, especially at paragraphs 35 to 62. And my lords, my ladies, the contention of the petitioners is that there were extensive illegalities and irregularities in the preparation and execution of this October election, that these constituted substantial violations of the Constitution and the election laws, and that this would compel that the election be invalidated. Indeed, my lords, my ladies, in Presidential Election Petition 1 of 2017, which my colleagues have been referring to as Raila Odinga 2017, this honorable court held that an election will be vitiated on account of illegalities and irregularities. So it is settled law that if we could demonstrate the illegalities and the irregularities, the court might find itself with no option but to do that which it said it would do in Raila 2017. My lords, we contend that there were a number of irregularities, and in addition to the affidavit of Billy Atudo, we also appreciate indeed the affidavit supplied by the respondents, especially the third respondent, because a lot of them are actually corroborative of our own affidavits. We contend that there were irregularities in the voter register, that there were irregularities in the voter turnout, or more accurately, recording the voter turnout, which involves identifying those that are allowed and not allowed to vote. And three, that there were irregularities again in counting, tallying, and transmission, more or less the famous forms 34, A, B, C, and indeed form 32A. With regard to the voters' register, my lords, my lady.
Excuse me, what irregularity was there in counting?
Sorry, in form 34A, in the recording of the counting in form 34A.
Okay, can you say a bit more on that?
Yes, my lord, I intend to. Yes, my lord, I intend to. So to just go first to before the voting day and then the voting day and after the voting day, and in so doing address the voter register and then the turnout and then the counting, tallying, and transmission. My lords, the voter register continues to be a moving target. The voter register is like the Incredible Hulk, which starts at size, bloats up to fulfill certain tasks, and then shrinks back again when that is done. The voter register that we started out with in June is what we have now. But in between, it has bloated. In June, in the gazetted voter register, we had 19,611,423 registered voters in the gazetted voter register. In August, when announcing the results of the August 8th election, we actually had two different figures, both of which were higher than the June figure. The chairperson of the IEBC, when verbally reading out the results, read that the total number of registered voters was 19,631,796. So from 611,423 to 631,796. Yet, when the form 34C was ultimately gazetted, this figure now was 19,611,457. The Form 34C, in relation to the October election, now has a figure exactly like that gazetted in June, and that's 19,611,423. So between June and August, the verbal announcement at least, there was an increase of registered voters numbering 20,373.
Where is this verbal announcement?
The verbal announcement is referred to in our bundle, Volume 1. My lords will get for me in a second, and I'll get back to it. So we see numbers that vary, go up and go down. The next thing, my lords, just to save time, as I try and get that for me, is with relation to identification and authentication of those who are entitled to vote. Regulation 69, my lords, or my ladies, of the Elections General Regulations, 2012 as amended, refer to, and this again was interpreted and was referred to yesterday in Civil Appeal number 258 of 2017, that talks about the difference between biometric identification and non-biometric identification, and describes that the fingerprint identification is a biometric identification. And there are a number of other non-biometric identification methods, or rather authentication, which include alphanumeric document search, alphanumeric and document search. So looking at the figures, and this is in the table in paragraph 15 of the affidavit of Billy Atudo, but also is in the report, the Otimofo report, as I said, which was shared by the IEBC and also is part of what we got from the third respondent. We look at those that were identified by KIMS in the first instance and those that were identified using the other means. And the figures that we have, or the figures that are then coming out, is that a total of 5.5 million people were identified by KIMS in the first instance. That's biometric identification. Then another 1.6 million were identified alphanumerically. And 428,043 were identified by document search. And there's a smaller figure of 78,124 who were not identified on the KIMS kit at all and therefore were on the copy register. So my lords, my ladies, with regard to this, we should have access, and we did ask for, the Forms 32A. If we could have Form 32A, or if the IEBC could demonstrate that they do have Forms 32A in respect of all that were not identified biometrically. Remember, biometrically identification were those that had the fingerprints. So, could it be beyond those that had the fingerprints? If one looks at those that were identified by document search, those who were identified by ID or passport number, either by keying in, alphanumeric keying in the ID or passport number, or by scanning the barcode. If you look at this figure of 1.6, access to the Forms 32A would then be able to help us verify that indeed they were identified properly.
With all due respect, my lords, are we reopening scrutiny application?
Okay. Okay. All right. Thank you very much, and thank you, Kimani. Then moving on to the issue of rejected objected votes and disputed votes. And the Forms 34A and Forms 34B. Yes, my lord.
I was wondering.
Yes.
Help me to recollect. Rejected and disputed votes. Are they in your petition?
Okay. Because I can't find out immediately. Not as an issue, my lords.
So you can't submit on what is not in your. I'm being magnanimous to you and giving you a bit of time, but I can't allow you to submit on what is not in your petition.
My lords, I'll skip that for now. With your indulgence and with gratitude, I'll skip that. Let me say that. I'll skip that. I'm sorry. I think just the rush of time is also putting us in an agitated, anxious position. So let me move on to the forms, my lords. As I said, that we had issues around the voter register, around voter identification, and around the forms. And to be very brief, my lords, my ladies, let me just talk about them in the sense of Forms 34A, Forms 34B, and leave it at that. And if I have a moment, I can then sum up. With Forms 34A, part of our contention...
Mr. Day, if I may just be of help here.
Yes.
You've been given orders to access the originals of 34A.
Yes.
Will it help your case if you wait for whatever you're going to get there, then in your submissions tomorrow, you can raise that issue? Otherwise, I'm seeing a situation where you raise some issues now on the forms, and tomorrow you do the same thing. How do we save time? And you're not helping us with that.
Thank you very much, my lord. I thank you for that, and I think that we will go with that we reserve any observations on the forms until tomorrow. In so doing, my lords, I would then not also go on to the authorities that I had that was in relation to that, and let that also come tomorrow. And I'll just say that in finishing, I would like to just add a word in answer to the question that was asked by the Honorable Professor Zhuang around those that chose not to vote. And on top of what my colleague said, to just say that there are those who chose not to vote, but there are those who could not vote. And the worry were those who could not vote for one reason or another. Those who could not vote because the polling station did not open, those who could not vote because of intimidation, those who could not vote because of violence, and knowing that the submissions that my colleagues have made is the intimidation and the violence, in our view, were both from state as well as non-state actors. So, in summing, on the election that was to happen in 60 days, we believe that the order of the court and also the requirement of the Constitution and the laws is that it's not just that there must be an election in 60 days, but that that election must be in strict compliance with the Constitution and with the laws. And we feel that if this was not possible, or if the contention is that if the first and second respondent, the National Returning Officer, and the Independent Electoral and Boundaries Commission, if the totality of everything before them, the decisions of the court, including adding candidates that they did not initially add, the violence that had occurred, any other logistical challenges, if they felt that they would be forced to do an election on the 60th day, but that was not in strict compliance with the Constitution and the laws, they had the option of coming back to this honorable court and seeking the directions of this court. That what do we do if the time is running out, we need to hold an election, but it will not be in strict compliance with the dictates of this court, but more importantly, of the Constitution and of the laws. And with that, my ladies, my lords, and beg to rest. And thank you for the indulgence that you have shown to our entire team.
Thank you. Thank you very much, Council. I think that is a good point to adjourn. Please go and have lunch. Have enough to keep you up to the time we rise. So we will...
Could Your Lordship, before you make the order, make a plea that you give us 2 hours. we take some food and then we look at our papers and we are refreshed and energized.
This is 3:15. Let's come back at 4:30. Yeah, 4:30, please.
And met some like this, just like this.